Hi, everybody. Welcome back to the channel. Thanks for joining me today. In the next few minutes, we're going to kick the proverbial hornet's nest, I guess, in part one of two with my RV lemon lawyer friend, Mr. Ron Burdge. Now, as you may or may not know, the courts have been busy so far in 2024 with RV cases. Yes, they have. And that means that the lawyers at the RV manufacturers have been busy as well. Well, to bring us up to speed with some of the most recent happenings in the way of RVs and the law, I sat down recently with Ron Burdge to try and get him to simplify things so that folks who are not all that much in the know will finally know what's going on. By the way, as you're listening to this conversation, if you have a question or a comment about lemon RVs, don't keep them a secret. Go ahead and post them in the comments below. And if you'd like to catch more videos like this one about RVs and the law, type 1 in the comments below. If you don't really care much about hearing about the law and how it pertains to RVs, type 2. It seems like every time you and I visit, the subject drifts into RV warranties, Ron, and it's just quite confusing to me. Why does that subject and the confusion come? It can't be just from me, but most RVers don't understand their warranties. Why is that?
Well, quite frankly, the warranties are not, especially some of them, but they're not written in a plain English sort of way in order to take care of the customer. Instead, quite often they're written in trickier language that makes it harder for the customer to have legal rights, and sometimes takes away legal rights that the customer otherwise would have. I've had cases where, frankly, lawyers and judges even argue about what this means and what that means.
Well, isn't it true, though, that the one of the ways RVs and automobiles differ is the components that come into and to make up an RV come from all different kinds of suppliers, and that's why when you get your packet of stuff when you buy a new RV, it's like this thick. With warranties and things from lots of different suppliers. It's not like that when you buy a pickup truck. So you have to understand all those elements and components go into making that thing called an RV.
Sometimes that's true, at least to a degree. But don't forget that there's a lot of parts that go into an automobile that are not made by the manufacturer. They're just simply bought, and then they put them into the car. But the difference is that when you've got a car or a pickup truck and an ordinary manufacturer of those products, they don't nickel and dime you on saying, we don't cover this and we don't cover that, and that we just bought that and put it in it. That's what the RV industry does. The car industry, so to speak, they buy parts and put them in it too. But you know what? They have a warranty that just simply says, we cover it. They don't argue with you.
How do the manufacturers get by with having these warranties that we, the consumer, the average person, can't understand? Because I can just think about what they're saying. Well, if you read them, you'd understand them. I think they do have a point, but how do they get by with it, with being able to do this to people with all these exclusions and jump through this hoop, and then we might take care of it? Meanwhile, the clock is running out on your warranty. How do they get away with it?
There's a couple of reasons that they get away with it, I think. And one of them is that the Attorney General for the state that handles most of these RVs being manufactured and distributed, that's Indiana, does not appear to have a big, strong interest in making sure that the industry is fundamentally doing right by its buyers, let alone by its employees. So the result is there's not a lot of oversight, so to speak. The industry is left to run pretty much the way it wishes. Secondly, the industry has a very organized lobbying organization and corporate organization, RVIA, which represents the manufacturers, and then there's the Dealers Association. And they've been historically very aggressive in making sure that it was pretty much the Wild West when it came to manufacturing and warranting RVs.
I think most people that end up having a warranty issue on their RV, I'm just assuming, they don't realize that if they do have a problem with their manufacturer, something that can't be resolved maybe at the local level, the dealer level, that they're almost always required to file a lawsuit, not in the state where they're from, not in Texas or Arkansas or Washington, or, they're required to file a lawsuit up in Indiana where the RV was made. And I don't think most people know that until it comes time to what?
Yeah, I think you're absolutely right. A lot of these RV warranties say that if you're going to sue the manufacturer, you have to sue them where they are. And that's not the normal law in this country. Normally, in this country, when you buy a bad product, you can sue them right where you bought it. You don't have to go to the factory. The RV industry treats things totally different because they've been able to get away with it. And now many, many buyers are basically just rolling with it instead of realizing that they're losing a lot of legal rights because of these things the factories have been able to pull over the wool, so to speak, over a lot of eyes, both the consumer eyes, their own customers' eyes, and also the government that could be monitoring this and making them do right and chooses not to.
I think, could be wrong, but I think that the public is beginning to wake up. I'm hearing a lot of talk more than ever about why isn't there a class action filed against these manufacturers, like they do with a pesticide that causes cancer widespread. Have you drank water from Camp Lejeune or whatever? Those kinds of class action lawsuits. Have you ever been involved in something like that? And why isn't there something like a class action suit that goes after these manufacturers? I'm not suggesting we do that or not. I just wonder why that hasn't happened.
Typically, it doesn't happen because of the requirements in order to have a lawsuit like that as a class action. Take, for instance, Camp Lejeune. That's a good example. You had one place where one thing was happening, and the effect caused one kind of problem to the people who were victims of it. So everybody's in the same boat, so to speak, because of the same problem. With the RV industry, however, when you get a bad RV, you might have this problem. The next guy who bought the exact same RV might have that problem, a different problem. And so you end up with not enough what they call similarities in order to be able to say everybody's in the same boat. And if you can't do that, then it doesn't matter that they build RVs that are bad if all the parts that are bad on yours aren't the same as the bad parts on somebody else's. And so it becomes very difficult to have a class action because one of the requirements is that similarity among all of the consumers who are the victims of the practice. Now that's beginning to change in terms of some of the things the industry is now doing that are more broadly affecting a large quantity of people. You don't need a lot of people for a class action. What you need is that similarity of harm and cause.
What is the hubbub that I have heard about, started back in January when I started hearing about it, about a judge out in California made a decision that was kind of, it surprised the RV industry, and it was on behalf of the consumer. Go figure, from California. Tell us about that. Do you know about that?
Yeah, as a matter of fact, that's not the only case. There have been two cases out in California where the judges had a Thor case, and it's only Thor right now that has been in front of the court with this problem. But they had a Thor case, and it was filed locally in California by a consumer who was a California resident who bought an RV in California. And then they filed a lawsuit over it because it turned out to be problematic, defects and whatever, and they couldn't get it fixed in time. And so it became a breach of warranty, so to speak. And then after they filed the lawsuit in California, Thor files an answer that basically says, well, your warranty, which is what you're suing us under, says you have to sue us in Indiana. So you can't sue us here. You have to either drop your case and refile over there or else transfer your case over there. And that's what they ask the courts to do. Now, one of the things that's unique about all this, however, is that the law in Indiana is drastically different from the law in California. So they then turn and say that the warranty also says, by the way, that it's Indiana law that's going to apply. So you don't get any California rights. You got to go to Indiana, sue us, and you got to live with Indiana law no matter what it says. And that is how they argue on most all of them. Well, what happened in California was that California has a law that says you cannot give up voluntarily your own right to a jury trial. As a consumer, you have that right, and nobody can take that away. Well, the Thor warranties in a lot of these cases, apparently, and a lot of the Thor companies says you don't get a jury trial when you sue them. Instead, it all gets decided by some judge. You don't have
in Indiana. It gets decided by in Indiana.
In Indiana. And so what they were saying in California was, well, you can't sue us there. You got to sue us over here in Indiana. So let's transfer the case to Indiana. And then what the people there were saying and what their attorneys were saying is, well, we'll lose our rights. And so what Thor would then say is, well, okay, then we will let your Song Beverly warranty law apply in Indiana. And we won't insist on you not having a jury. We'll let you have a jury trial in Indiana. Sounds
Oh, how
pretty
nice
good.
of them.
Well, yeah, but there's a motive there for that, of course.
And what would that motive be, Mr. Burdge? I mean, I'm speculating. What would you think the motive is?
Well, the motive is a couple of things, and one of them just popped up in a case we've got that was transferred, and they had stipulated in California that California's warranty law called Song Beverly, that law would apply. And then when they get here, they're now saying, well, we didn't mean the whole law. We just meant that part that said this is what your rights are if you have a breach of warranty, but you still have to use Indiana law to figure that out. But that's not what the stipulation was, of course. So it's kind of like, get us over to Indiana, and then we'll let an Indiana judge decide whether or not California law is really going to apply, even though they've said it will apply. It's just a game. But there's a more ominous thing behind all of this, too, that can be their motive. There's a legal concept called interim. And what that means is that a company says something to a consumer that says, this is what your rights are and this is what you got to do. And the company knows that isn't true. But then the consumer, of course, not being a lawyer, and even if they get a lawyer, the lawyer may not realize it either. So they go along with it. So the effect of it is that there may be people in California who are told you can't sue there. They see in their warranty, it says, I got to go to Indiana to sue. And so they go to Indiana and sue. What they don't realize is when they voluntarily do that, follow the warranty that is, they lose their California rights. And those rights are vastly different from the legal rights of a breach of warranty in Indiana.
How can a consumer possibly know this stuff until it's too late? I mean, it sounds like the California judge did the right thing, but if I were Thor, I'd make the case also, well, they signed it and says, it has to be done in Indiana, which doesn't that cost the consumer more money? Because a lot of times lawyers can't practice. If you're a California lawyer, you're not necessarily licensed to practice in Indiana, which racks up the cost for these people.
It might, but it might not. And that idea that it makes them now have to come to Indiana, now they have to be sitting back thinking to themselves, I live in California, but now I got to go to Indiana. I have a lawyer here, but now I got to get a lawyer over there. And so people think to themselves, it's not worth it, or it's going to cost a lot, or it's going to be a lot more aggravation. Now we got to travel to Indiana in the winter. Why do I want to do that when I'm on the beach in San Diego? And so there's this interim effect. The effect, in other words, is I tell somebody they got to do it, even though they don't have to do it, and they just give up and go do it, not realizing they don't have to do it until it's too late. And so I get the benefit of that because I kind of scare them into it, I being the warranty manufacturer.
What a mess, right? I mean, it doesn't seem like it should be that difficult for RVers who have a legitimate claim against their manufacturer to go to court and get a little bit of justice, does it? But what do you think? Let's get the conversation going down below. And yes, tomorrow we'll conclude this visit with Ron Burdge, and we'll talk about the judges out in California who called what Thor is doing in their warranty a scheme. That's the judge's word, not mine, a scheme. So is this a pivotal point in the law, do you think, that may be swinging in our favor as a consumer? What do you think? My advice, if you need a lawyer regarding any kind of an RV issue, get someone who knows RVs, someone who understands their weird nature of how the law sees RVs. Links to some of my recommended contacts and resources is in the description down below. Until next time, I am the Wingman, reminding you, be safe, have fun, play nice, and don't leave your good manners at home. Bye-bye, everybody.